Okay, I think we're gonna get started. I know not everybody's back yet, but they can just walk in after I've already started. Thank you all so much for being here today. My name is Micah Held, and I'm a staff attorney here at LAF. I work in the Children and Families Practice Group, which means I do a lot of divorce cases, custody cases, orders of protection cases, as well as civil no contact orders, which I'll be talking about today, and I also do a little bit of education sometimes as it pertains to the sexual assault. But I'm not going to be talking about education because you have a very good speaker coming next to talk about that. So I want to talk to you all about civil no contact orders, also called a CNCO, and I'll be referring to it today as a CNCO. A CNCO is a protective order for a sexual assault victim. It's very much like an order of protection, but the reason it was created was because there are some survivors who are sexually assaulted by someone they're not in a relationship with. So people who are assaulted by an acquaintance, a stranger, a family friend. These, under our old laws, they weren't able to get an order of protection from that person who had raped them. Now that we have the Civil No Contact Order Act, any sexual assault victim can get a protective order for herself. It's very similar to the order of protection. It's the 2-year plenary. You can go in and get the emergency. The ways it differs from the order of protection is you don't need to prove you're in fear of that person. You don't need to prove any sort of pattern of abuse. It can be just the one-time incident, and judges say that's enough. If you can prove that this sexual assault happened, that's enough to give you a protective order. Now, there's also no time limit on it. So if somebody's been sexually assaulted 10 years ago and for whatever reason wants to come in and get a civil no contact order, they can. That's a little bit different than the order of protection. Judges are usually looking for recent incidents. Now, I'm not saying that there's a judge out there who's going to hand somebody a civil no contact order from an assault that happened 10 years ago, but there are circumstances that may lead to that. So just be open to that option for people who come in seeking help. Now, because of the fact that you can get a CNCO anytime, a lot of times emergency civil no contact orders are being denied because, as you all know from doing order of protection work, you kind of need to come in with a very recent incident. So if you're coming in with a sexual assault that happened last year, 3 months ago, or even last month, the judge may say, well, you may be able to prove your plenary case and get a plenary CNCO, but this isn't an emergency, and I'm not granting you the emergency because there's nothing showing me that this case is an emergency. So just be cognizant of that they may be denied the emergency, but that doesn't mean they don't have a good case and won't prevail for the plenary. If they do get an emergency civil no contact order, I think most of you know the deal with OPs. You have to keep coming back every 21 days to get it renewed. So if the victim doesn't have an attorney, unfortunately, she's going to be needing to go to court every 21 days. And as you all probably know, it can sometimes take a long time to serve the person. There can be a lot of delays in the court system, so it can mean a lot of different court dates. But they are supposed to be expedited proceedings, which means that the judge is supposed to focus on getting a hearing date soon. It just sometimes can't happen. I had a recent CNCO that took 11 months because it took us so long to serve him, and then there were so many delays where we had to make legal arguments, and finally we ended up getting it. So let's talk about what a CNCO is. Put simply, the petitioner must prove, by a preponderance of the evidence, that the respondent sexually assaulted him or her. So first of all, what does sexually assault mean? Sexual assault can be any penetration, however slight. It can also be sexual conduct. That's intentional touching or fondling. So you don't need actual penis to vagina penetration to get this. Also, anytime anybody has a question, please stop me. You don't have to hold your questions till the end, so feel free to ask questions at any time. You can also get a CNCO against somebody who aided and abetted the sexual assault. What does that mean? In a recent case I had, we had video evidence of there was 2 boys who drugged and then sexually assaulted my client. And she only knew about this because they videotaped it and put it on Snapchat. And somebody from school showed her the Snapchat. So in the videos, One of the boys is holding her mouth open while the other boy orally assaults her. Well, we filed a CNCO against him because he aided and abetted a sexual assault. He also probably sexually assaulted her. She doesn't remember anything from the night, but we didn't have that evidence. What we did have was the video of him opening her mouth. Preponderance of the evidence is the lowest standard of evidence. Some people in the legal field describe it as proving by 51%. So it should be the easiest standard of evidence to get something as compared to a criminal case, which is beyond a reasonable doubt, very difficult to get. Preponderance of the evidence is easier, but don't assume that that means it's easy to get a CNCO. It is not. We've actually found it's harder to get a CNCO than an OP because judges are less likely to be educated on sexual assault than they are on domestic violence, and there's just still a lot of myths surrounding sexual assault. A CNCO can also protect family or household members just like an OP can. I wanted to let this audience especially know that there's a provision to protect any employee or volunteer of a rape crisis center providing services to the petitioner. So if there's some sort of scenario where you or another staff member where you work is being threatened by this guy, I just want you all to know that this is an option. I've never had to use it. I don't know anybody who has, but just know that this is something that you are also protected under this. If the victim is under the age of 18 or they have a disability, a parent or guardian can file this CNCO on behalf of them. So that's always an option. Let's talk about how CNCOs interact with the criminal justice system, because I'm sure what you've already seen or what you're going to see is that many of these cases have criminal components. They've reported to police, police are investigating. So how does that work with the CNCO? How can these cases hurt each other? How can they help each other? What are some common things that are going to happen? So first of all, a victim can get a CNCO even if the police are investigating or the state's attorney is prosecuting. So a lot of times people think, oh, the state's attorney, they're going to handle all that, they're going to protect me. Not necessarily. First of all, sometimes the police can take a long time to do their jobs. So while they're waiting for this investigation to continue, they're feeling totally vulnerable and unprotected. So they are able to go get a CNCO. Sometimes the state's attorney will do an OP with a DV case, and they can do the same thing for a sexual assault case or special conditions of bond, but you can't always get the same protections you can in the CNCO. So if there are certain, and also the state's attorney isn't always communicating very well with the victim. I have a case where my client didn't even know that there was a special order of bond out. So it's very important that the victim knows that she can get a CNCO even while a criminal case is pending. Why would a victim want a CNCO while a criminal case is pending? Well, we've already talked about some of the reasons that the state's attorney doesn't always do everything they can to protect victims. Also, just because police are investigating or a state's attorney is involved doesn't mean they're going to prosecute the case. Many sexual assault cases are rejected. In fact, most of them are rejected. So sometimes a CNCO is the only recourse a victim has. It's the only place where his or her voice can be heard, where they can talk to a judge about what happened to them, and it's really the only option. If there is a criminal investigation going on during the CNCO process, the state's attorney may not want the victim testifying at a CNCO hearing. So there may be some pushback to the victim that if you go forward with this, we're not going to do our criminal case. Well, that's up to the state's attorney, and maybe they really won't. They really shouldn't be making blatant threats like that because it is a victim's choice to go forward with a CNCO. But that is a possibility because when a victim testifies at a CNCO hearing, whatever she says can be used to impeach her in a criminal case. That means the defense attorney can get the transcript from the CNCO hearing and use any little inconsistency, which we all know that there are going to be some because it's impossible to tell the exact same story twice, to harm the victim during the criminal case. Now, I've never had a state's attorney say, we're not going forward if you go forward. So I don't think it happens that often, but just so you know, it's something that could be communicated to a victim. Now, it's the same thing with the respondent, and that's where things are sort of advantageous for our clients in terms of getting a CNCO. If there's a criminal investigation going on, attorneys for respondents are going to say, don't testify at this. Anything you say will be used against you in a criminal case, and we do not want you saying anything during this. Which is great news for us, because when the respondents don't testify, the judge can make an adverse inference from them not testifying. Everything our client has said is undisputed, and we usually win those cases. So I've often tried to use that to my advantage during CNCOs by trying to push the criminal case forward, so I can turn to the respondent's attorney and say, you really don't want your guy testifying, do you? Why don't you just agree to this? And sometimes they do, which is great because it means our clients don't have to testify. You can also sometimes use evidence in the criminal case in the CNCO case. So this is something I use very often in my cases. If there's a CAC video, if there's been an interview with the respondent, if there's any sort of social media evidence they're getting, which, by the way, they have a way easier time getting social media evidence than I do. So those are things that I can issue subpoenas for, or if the victim is representing herself, that she can get help in issuing subpoenas to get some of that evidence to use in her CNCO case. So just because the detectives collected the evidence doesn't mean that she can't use it in her case. You can also potentially use the detective's testimony in your case, assuming he or she is willing and assuming that they have helpful information for you. Some special provisions of the CNCO, and this is a little bit different than an OP. In a CNCO, the petitioner can testify in chambers if he or she can show serious emotional distress. What does it mean to testify in chambers? Well, that means you're not in the open courtroom with everybody in there, that hectic, chaotic courtroom where you have to stand up. You actually get to go back to the judge's office, and it's you, the judge, the respondent's attorney, and your attorney. So obviously you don't want to pursue this if the respondent doesn't have an attorney, because then the respondent is his own attorney and he's going to be in that small room with you. But in cases where the respondent is represented, this is a really great option to pursue. This allows our clients to have less stress and anxiety and to not have to face their attacker. They get to be in the room with the judge, not having to talk about this in front of everybody. Now, how do you get this? You have to file a motion asking if the client can testify in chambers, and you have to show serious emotional distress. Well, you can go about this in a few ways. We've been submitting letters or affidavits from clients' therapists. An affidavit that the client has written saying that it would cause serious emotional distress to testify in open court may be enough. I've never had to argue that issue. Or there may be a judge who wants the therapist to come in person and testify. But these are all examples of things you can do to make it the best possible scenario, the hearing date for a victim. It usually works well if the client is younger than 18. I have tried it on older people. I haven't been successful yet. But if you can't get testimony in chambers, a backup option is to have the victim ask for a closed courtroom. A lot of judges do this anyway, but some don't. They're in the middle of a hectic day. They have a ton of cases. They forget to clear out the courtroom. But if a victim asks for a courtroom to be cleared during his or her testimony, a judge will almost always do it. So that's something that they should ask for, because it's really, really uncomfortable to talk in front of a room full of people about being sexually assaulted. There's no testimony about past sexual history allowed. It's the Rape Shield Act, and it does apply to civil cases as well as criminal, unless the judge rules it admissible. In order for the judge to rule it admissible, the respondent or his attorney has to file a motion. So you're going to know it's coming. It's not going to come out of nowhere. If it does, the judge should shut it down, or hopefully the petitioner's attorney or the petitioner. But you can let her know that this shouldn't be a fear that her past sex life is going to be talked about, because it shouldn't be. Another special provision of a CNCO that we don't see in OPs is that if the respondent and petitioner attend the same school, the judge can order the respondent to transfer schools. This is huge for our clients. You can't even imagine what it's like to have to go to school with the person who raped you. So we're incredibly lucky that the Illinois legislature put this in the statute. We haven't seen a lot of these cases, but right now we're working on one of these cases with an 11-year-old victim who was sexually assaulted by a classmate. They're in 6th grade right now. If we don't win this CNCO and get this respondent transferred, he will have to go to school with this kid for 7 years. Not a fun prospect for him. So that's something people should also know is an option. You have to check off a box when you file the petition for CNCO. In terms of getting a CNCO, first of all, where do you get it? Anybody can go to 555 West Harrison to get a CNCO, just like where you would get OPs. But if it's a client in the suburbs, they can also go to one of their local courthouses like Rolling Meadows, Skokie, Markham, and you should also be able to obtain one there. Even if you live in the suburbs, though, you can still come to 555 West Harrison to get one. So the first thing that's going to happen is they're going to file a petition for a CNCO alleging the sexual assault. Doesn't have to be super detailed. In fact, sometimes it's better if it's not. And once they file that, the respondent has to be served. So also a problem we've run into is when the client doesn't know where the respondent lives. Maybe this was an acquaintance or a stranger who raped them. What if they don't know where they live? Well, if it's a stranger and they don't know who it is and literally have no idea where they lived, unfortunately, you're probably not going to be able to get one. We had a case where it was the two acquaintances from school, the ones who drugged her and then put it on Snapchat. She didn't know where they lived. She wasn't that close of friends with them. She just knew them. So we were able, because there was a criminal investigation open, we were still able to get a CNCO and just ask that the police list their address on the summons. So the police communicated with the sheriff at 555, and we were able to serve both of them. So that's another option, even if they don't know exactly where they live. If you're unable to serve because you can't find the person, you have to go through publication, publish the case. That can take a few months. But at the end of that all, if you just publish the case or they're not able to be served, you can get a default 2-year plenary civil no contact order against the person. Then, of course, also this is the same with OPs. If the respondent is served and doesn't show up, wonderful. Step up and ask for that plenary 2-year CNCO. As I mentioned before, the victim, if they don't have an attorney, will likely have to return for a bunch of court dates just to get all this stuff squared away. If they do have an attorney, that's great, because a lot of times the judge will say, okay, they don't have to keep showing up for the court dates while we're trying to serve this guy 5 times. The attorney can just show up. So once he is served, and if he does appear in court, then you set a hearing date, or sometimes there's just discovery issues that take a little bit longer. Sometimes somebody is trying to issue subpoenas for evidence, so sometimes it can drag out a little bit, but usually once the respondent is served and shows up, you set a court date for the hearing. The layout, again, it's pretty similar to an OP. I just wanted to point out a few different things you might use in a sexual assault case. So the petitioner presents his or her case first, and that can be anything that they want to use as evidence. First and foremost, their own testimony. Now, if you have a child under the age of 13 who's been sexually assaulted, there are some exceptions where they may not have to testify. So if you run into that situation, it's hard to cover here, but you can always reach out to LAF and we can talk through and give some advice about that scenario. Because there are rules in Illinois saying that children under 13 don't always have to testify about sexual assault. If they have any witnesses, and obviously sexual assault is usually done in private, there aren't witnesses to an actual assault typically, but you can use outcry witnesses. Who did the victim tell first? That person can potentially testify. As I mentioned before, maybe the detective, if they've done an interview with the respondent and think he's a total liar and are going to be really helpful to your case, that's somebody. There cannot be any character witnesses. Nobody can come in and say, I know the victim, she never lies, she's such a good girl, none of that. If the victim has any documentary evidence, a lot of times there's text messages back and forth between them, either before or after the assault. Those can always be really useful. Sometimes there's social media evidence. Often there's medical records, but be careful with the medical records. We were trying to use medical records in one of our sexual assault cases, and the doctor had asked the 17-year-old client if she'd had sex before, and she answered yes. We obviously didn't want that to come in front of the judge. We didn't want it to be prejudicial. So we were able to black that out when we turned over the medical records. But just, it's always best if the victim can take a look at her own, or the attorney can look at the medical records first before handing them over to the other side or presenting them to the judge, because there can sometimes be things in there that you don't want to get out. And so any other evidence that the petitioner has, they present their case. Once they're done presenting their case, the respondent presents his or her case. Same thing, no character witnesses. Nobody can come in and be like, I'm his coach, he's a great kid, he would never do this. No, that can't happen. No teachers, nothing like that. Once he presents his case, which same as the petitioner, if he has any witnesses, if he has any documentary evidence, after they're both done, they make a closing argument. And this is something you all can be really helpful to clients on. If they don't have an attorney and they don't know how to make a closing argument, you can help work with them to prepare something that they would want to say to the judge. Does anybody have any questions about CNCOs? Because we're going to move to stalking no contact orders. Yes?
Mike, I did have one quick question. You mentioned that you were working with somebody to get another child transferred out of the school. Just by the fact that you said you're still working with them on that, I'm guessing that's not available in an emergency. Is it only a plenary?
Yeah, you'd have to get the plenary. We were denied the emergency because, as you know, we didn't get it close enough in time to the sexual assault, which happened over the summer. But yeah, I don't think that's relief a judge would grant during an emergency. I think they would want it, because you have to first prove the sexual assault, and I think you would need the other side to be able to present their case, because once you prove the sexual assault, the burden shifts to the other side to prove why they shouldn't have to transfer schools. Yes.
What are some civil liabilities an abuser can face?
What do you mean by civil liabilities?
Are there any additional lawsuits other than CNCO?
There is one, and I'll get to it at the end. Yeah. Anything else about CNCOs? Yes.
You mentioned the case they were minors, so when they're served, I know sometimes most judges orders of protections, you know, if they're 13, 14, won't even issue. Do you have problems with that, or do you serve the parents, or how does that work?
I've never had a judge say anything about serving a minor. What they will say is, on the return date, if the response there, they will say they want the parent with them. So like they don't want the child alone in court. But as far as service, I've never had an issue. Have you run into issues with that?
Yeah.
Okay.
They won't even, some judges, they'll ask what's the age of the respondent, and if we said 13, they're like, there's no way I'll issue an order against a 13-year-old.
Oh. Well, please let us know if you have situations like that. I'm sure we'd like to be on that. Okay. We'll move on to stalking no contact orders, but if there's more questions about CNCOs at the end, we can certainly come back. Stalking no contact orders. So there's 3 types of protective orders in Illinois. There's the OPs, there's the CNCOs that we just talked about, and then there's stalking no contact orders. I just want to say from the get-go, we don't do many of these at LAF. I haven't done any of these, but I'm just going to tell you a little bit because you may encounter a client who's only eligible for an SNCO as opposed to an order of protection or a CNCO. So in this one, like the CNCO, you don't need a relationship between the petitioner and respondent. We pretty much only would use this if we couldn't get a CNCO or an OP. So this is kind of a last resort protective order just because judges aren't as willing to grant it as they are the other 2. There needs to be 2 incidents of stalking in order to try to get this. And these are acts in which a respondent directly or indirectly or through third parties follows, monitors, observes, surveils, threatens, communicates to or about a person engages in other contact or interferes with or damages a person's property or pet. So this is pretty broad, but it's just really hard for people to get them for whatever reason. I think a lot of people bring them kind of improperly, like a neighbor dispute, and it's not exactly the right forum. So the behavior of the respondent needs to put a reasonable person in fear for their safety or cause them emotional distress. Now, what does reasonable person mean? A lot of times when you say reasonable person, it's the reasonable man. Would a reasonable man be upset by this, be put in fear by this? But this statute specifically says it's a reasonable person in the petitioner's shoes. So having the information the petitioner had, would a reasonable person be in fear of the respondent? I'm going to give you an example. This was in a different context because this was a CNCO I got, but if we were trying to get a stalking no contact order, here's what the example would be. My client had a boss who was sexually assaulting her. He hadn't sexually assaulted her in a while, but he said to her, we need to have an after-work meeting or a Saturday meeting. That was what he always said. And she said, that was when I went right away to the police. I was so scared. And I said, why in the world would you be scared by that, having a Saturday meeting? That's a pretty normal thing. Any reasonable person, any one of us, wouldn't be scared of a Saturday meeting with our boss. Well, the reason she was scared is because that was what he had always said to her in the past before he sexually assaulted her. So she knew when he said that, that was the cue that she was going to be raped. So that's what we mean when we say it's a reasonable person in the petitioner's shoes. What information does the petitioner have that we don't have that put her in fear? So you really have to get at that issue. Why is she in fear? Finally, we're going to talk about the Gender Violence Act. You had asked about other remedies against a rapist. The Gender Violence Act is specific to Illinois. I think California is the only other state that has a similar statute. Actually, there might be a few more that have gotten it, but us in California were the first two states to have this. And it's any person who has been subjected to gender-related violence may bring a civil action for damages, injunctive relief, or other relief. Gender-related violence, so this includes domestic violence as well. Put simply, a victim can sue her attacker for monetary damages. Well, we're not seeing many cases of these. First of all, it's a fairly new law, early 2000s. But there's also not many cases because not all rapists have money. In order to pursue a lawsuit like this, you're going to want to go after somebody who has money. You can sometimes, and I would say even on rare occasions, sue third parties like an employer or a school under this act. But there has to be a really, really strong connection between what the employer or school or third-party entity did to help cause the rape. You can't just go after the school because it happened on campus. So that's a possibility, but not a very strong one. Now, the nice thing about this act that differs from other what we call torts, like civil lawsuits, is most civil lawsuits, you have a 2-year statute of limitations. You have to file a suit very, very quickly after it happens. Now, we all know victims aren't always ready to go forward after 2 years. It takes time to think about this, to recover, to get back to a place where you can be strong enough to go after your attacker in court like this, because it takes a lot. You're going to be in litigation for a few years. You're going to have to testify. You're going to have to do a deposition. You're going to have to be doing a lot, and it is emotionally draining. So this law is nice because you have 7 years to file the case, and you have even longer if you were a minor when you were sexually assaulted. You have 7 years past when you turn 18. So that's really nice. Now, as I said, we don't see that many of these cases, but your antenna should go off if a client is telling you, the attacker has a lot of money. He's a CEO of a big company. He's this, he's that. Somebody that has money. And sometimes victims aren't even suing to get money. You're using this strategically to get something else that you want, because you can always settle out of court for something other than money or in addition to money. Yes?
So the attacker had to be convicted?
No. No criminal conviction necessary for this.
what do you need in order to prove?
Well, it's going to be the same thing just like it is in a CNCO or any other civil case. You're taking your evidence, first and foremost, your testimony. Are you credible on the stand? Are you remembering a lot of details? Are you getting caught in lies? So your testimony is going to be one piece of evidence, and then whatever other evidence you can gather, things that I mentioned in the previous case, social media, text messages, any outcry witnesses. Maybe you have mental health records that can help prove your case. So you can kind of be creative. But I would say this isn't the type of action a victim would take on by herself. This is definitely the kind of case I think an attorney would have to file. But if you have a victim you think this would be a potential good fit for, definitely refer them here or to another lawyer to see if this is a possibility. Yes.
Are these suits done at the day center?
Yeah, they can be in the law division, I believe.
Okay.
Yes, law, I think.
Is that the only
right,
place
Cynthia?
downtown?
Yes, I believe so. Cynthia, do you know?
I actually don't know, but it sounds right.
Okay.
It's just a damages,
Yeah.
it's a damages case.
Yeah.
Yeah.
Yeah, so I think it would have to be at although I suppose why couldn't you file at the suburban courthouses too?
Right.
Yeah.
I think it could be any of the civil court districts in, the circuit court of County, or, anywhere in the state. But it's not a federal case.
Yeah.
Even at DB court then, if it's any civil court?
I don't
It's
think.
a specialized court,
Yeah.
but, all the suburban courts and the jail center have general jurisdiction courts, so that's where.
Yeah.